This podcast discusses sexual violence and other material listeners may find distressing. Please look after yourself as you listen and feel free to switch off at any point. You can visit withyouwecan.org to find help, but remember to call 000 in emergencies. We're recording on the lands of the Gadigal, where sovereignty was never ceded. We recognise that Aboriginal and Torres Strait Islander peoples continue to experience the ongoing impacts of colonisation, including disproportionate rates of sexual violence and institutional harm. We pay our respects to elders past and present and commit to advocacy that does not replicate the harms it seeks to address. Always was, always will be, Aboriginal land. Victim survivors live in a constant state of the unknown. I know that because I've lived it. Shrouded in secrecy, silenced by process, we're asked to place our faith in a justice system that was never designed for us, at the most vulnerable moment of our lives. But I won't stand for it. We're cracking this system wide open so you and everyone around you understands what it actually means to navigate the legal system after sexual violence. I'm Sarah Rosenberg, Executive Director of With You We Can, and this is what no one told us.
Lara Freidin is a law reform advocate who spent more than a decade working to improve how the legal system responds to violence against women. Her work sits at the intersection of legal practice, policy and advocacy, translating the experience of victim survivors into practical reforms to laws, systems and institutions. Lara recently established Wildfire Advisory, a consulting practice that supports organisations and advocates to navigate law reform and influence change. She's currently working with me and the team at With You We Can to support efforts to embed independent legal representation for victim survivors of sexual violence in legislation. Fair warning, we're about to take listeners into something that's just a little complex. We've designed a process around evidence, but not around the person expected to carry it. So come with us as Lara and I try to unpack the structural reality of Australia's justice system and what we're trying to change about it. Lara, I'm very happy to have you here with me. We've known each other for a while now.
Yes, I think we've known each other, I was just thinking about it before, maybe around 3 or 4 years.
Besties!
Yeah, because we first met when I had just started working with the Women's Legal Services and you had just started setting up your hub and trying to kind of expand the information so it was relevant to every state and territory.
Yeah.
Yeah, and then...
That old thing.
Yeah. And then we ended up figuring out how we could advocate together.
I thought you were scary on Zoom.
Really?
Yeah. Have I not told you that?
Do you think I'm scary now?
No.
You don't
is
have
that
to answer
offensive? No. I'm not intimidated by you. Ugh. It sounds insulting either way. Okay. Let's get into this.
Sure.
We'll be on Struggle Street, a familiar place for us. Mm-hmm. Okay, let's start really simply. If someone reports sexual violence in Australia, where do they sit in the legal process?
Well, I think what victim survivors often find is that they're actually not necessarily a huge part of the criminal justice process. So when victims report that they've been sexually assaulted, it will then become a matter that the police investigate, the prosecution will then prosecute it, the accused person, if it goes that far, if there's a charge, they will then usually get legal assistance, so they'll have their own legal advice and counsel, but the victim, they won't have their own lawyer. And so they don't actually sit as a key part of the criminal justice process. And I think that can often be a shock.
What does it mean in practice that you're not a party to your own case or the case against your own perpetrator?
Yeah, so in criminal law proceedings, you have the prosecutor who represents the state, and then you have the accused person, and they're the two parties to the proceeding. And so the victim isn't actually a party. And what that means is generally they don't have the right to appear in court, they don't have the right to make submissions to the court, and it's really up to the prosecutor to decide how the case will be run, really whether they'll run it at all. What kind of deals they might make with the accused person and their lawyer. And so, because the victim isn't a party to the proceedings, the rights that they have are quite limited.
I think people hear no legal representation and then they don't really understand the impact of what that means. So, you know, all of the decisions that are being made between the prosecution and the accused and not the victim.
Yeah.
The victim still, you know, they have interests. What are some examples of when a victim's interests diverge from the prosecution's?
Well, so the prosecution might, for example, decide that there's not enough evidence for them to proceed with a prosecution. They might decide to strike a deal with the accused around, I guess, what they'll plead guilty to, what they won't, what charges will be dropped, what charges will continue, things like that. And so there's quite a few things that the prosecution will decide throughout the justice process that they don't necessarily need to consult the victim on. But as we've seen over recent years, as there's been more and more recognition that victims should be treated as participants in the process, the prosecutors do have to consult victims more and more. So we are seeing, for example, to ensure compliance with victims' charters, we're seeing prosecutors have to talk to victims, make sure they feel heard, make sure they feel respected and seen throughout the process, and also talk to them about serious decisions throughout the matter. But yeah, there's a whole range of things that they won't consult the victim on, which can be really, really frustrating, I think, for victims of sexual assault.
I want to talk about counselling notes because you and I have different perspectives about victims' counselling notes being accessed. Not that they're contradictory at all, but the accessing of victims' counselling notes could be seen as, you know, an example of where the victim's interests diverge from the prosecution's, because the prosecution might want to access evidence that the victim disclosed early, you know, in line with, you know, rape myths, trauma myths, all of it. Whereas the victim might not want their privacy invaded like that. So that can be a really clear example. But I feel like it's not even as distinct as that. Like, really, for me, I just go, protecting the victim's privacy is arguably the only interest the state should have, because invading their privacy and humiliating and discrediting them with information that's been taken from their private records and has been distorted, which we know happens all the time, is not in the state's interest, because it's just adding to the defence's argument that the victim is someone not to be believed. So it's kind of like you're doing the defence's job for them in front of the eyes of the jury. But there are circumstances where evidence that a victim has disclosed, or evidence that they've done a forensic medical exam, or evidence of injury can be useful because it's corroborative evidence. Anyway, what happens when things like counselling notes or medical records are subpoenaed? How are they accessed?
Yeah, so firstly, I think it's really important to hear you talk about the impact that accessing confidential records, including your counselling records and health records, had on you personally. And I think, you know, what I've heard from victim survivors all across the country is that if they'd known that their counselling records were going to be accessed, or their private health records, that they maybe wouldn't have even reported the sexual assault in the first place. And I think that is also a huge shock to people, to find out that that is going to happen. And I repeatedly hear from people that it is such a huge invasion of their privacy. And so, yeah, when you say, I can't see how that should ever be useful evidence, like, I really hear that. And, you know, I feel that, like, you should be able to meet with your counsellor and talk about the impact of whatever's happening in your life on you, with no fear that you need to monitor yourself and worry about what you're saying. So yeah, firstly, I just wanted to say that. But essentially, in response to your question, the police and the prosecutor can seek evidence, and so can the accused person. So the victim of the sexual assault might receive a subpoena from any of those different kind of actors for their personal records. In some states and territories, they'll need to seek the leave of the court to request access to that information. And in some states, there's just a complete ban on accessing counselling records. And then it's up to the victim to decide whether or not they want to allow that evidence to be part of the brief or to be adduced into the evidence that's relevant in the proceedings. And then, there is discussion about whether there should be a complete ban on that evidence being allowed in at all. And I think that's a really important conversation for law reform experts and advocates and people with lived experience to be having, and government, obviously, and decision makers. And it's great that that is now happening across the country.
We know that states where defence barristers have to apply for leave, which just means, asking permission from a judge, and even states where there's an absolute ban like Tasmania, there are still circumstances where private records are accessed unlawfully, my case being an example of that. And it's terrifying because we're kind of like at a level where victims won't even know why that information is being accessed. Like, if you're aware of the system and you're reading the news, like, maybe you've got a low-level understanding. But for the most part, it's such a bizarre... I mean, I found out my records were being accessed because I got a call from a doctor I hadn't seen since I was a teenager, and she was asking what she should do, like comply with a subpoena, as if I knew, because remember, I'm not in charge. I was the victim. And New South Wales, where I went through the system, victims are given standing during hearings to, challenge those access attempts, whether they're accessed in the first place, too late for me, and whether they should use the information in those records to question you in cross-examination. Can you talk a little bit about the link between legislation and legal standing?
Yeah, sure. So you're right. There are quite a few states that allow a victim of sexual offences to have a lawyer that will actually appear in court and make submissions about whether that evidence should be accessed or admitted into the evidence. I think what's really important is for people to understand is that often victims of sexual assault don't get any legal advice. So they won't be provided with free legal assistance that's government funded, or they won't know that they have the ability to get free legal assistance. There's also very limited legal assistance available because of services being significantly underfunded. So when I say that, I mean legal aid commissions are significantly underfunded, but they primarily provide legal assistance to the accused person. But in some jurisdictions, they also will assist the victim with protecting their confidential counselling records. And then you also have women's legal services, community legal centres that can sometimes help with that as well. But again, they're very underfunded and they're not readily available. And so if you can afford your own legal assistance or legal advice, then that's a really useful thing for people to do before they even report to police, so that they will then understand that this evidence can be requested, it can be accessed, it can be used against you essentially, or prevent you from achieving what you want to achieve through the justice process. And so, yes, so what we have is a kind of a lack of legal literacy in the community, which needs to be improved by access to legal assistance. It's very difficult to get. People don't know they need it. And then once you do get legal advice, if you do, that can be really useful to then understand your options. But actually having a lawyer with you in court is very, very limited. So what we have is what you've referred to, which is standing. And so that's the legal principle that kind of underpins whether or not you can stand and appear in court on behalf of someone, on behalf of a party, or on behalf of a person who's not a party. And that's what we're talking about here, is whether victims and their lawyers should have standing to appear in court. And there has been recognised that there should be limited circumstances where you have standing in court, and that is in relation to protecting confidential counselling records and in some states health information as well. And so what needs to happen, and this is what you and I have been talking about for a long time and advocating on nationally, is that there needs to be standing for victims in all criminal proceedings, to protect access to their confidential records and to protect access to not only their confidential records in relation to counselling, health records, your phone records, a diary that you wrote to yourself, when you were a teenager could be accessed, any kind of personal confidential information, something that government has about you, for example, your social security records, if you've been involved in child protection. And so all of that information can be accessed. And so you should have a lawyer that can actually represent you in court to say whether or not that information should be used, because it is so impactful for victims and such a huge invasion of their privacy. There's a few other areas where we think that it would be useful for victims to have standing, and that's in relation to their sexual history evidence and whether that should be, whether their sexual history should be discussed openly by the court, and whether it should be relevant to determining whether or not a victim survivor consented to the sexual activity. And then we also think that victims should have a lawyer to represent them when they're being cross-examined, because we know that it can be really, really difficult and re-traumatizing and painful and harmful for victims to be aggressively questioned, harassed, bullied, intimidated by the defence counsel. And often, not all the time, but often it can be difficult for prosecutors to object to those lines of questioning, because it might be evidence that might actually be beneficial for the prosecution's case, and so but at the sake of the victim's mental health and their own sense of self and well-being.
As we talk about relevance, and it's interesting because sometimes it's actually just as nasty as wanting to elicit tears or a trauma response from a victim on the stand. And then you can talk about relevance as well of, is it relevant that they have now been diagnosed with PTSD as a result of the assault? And that's relevant as evidence of harm, but what we know happens, it's that gets distorted to come up with a way to suggest that their PTSD makes their memory unreliable, and therefore they invented the assault that supposedly gave them the PTSD in the first place. And we see this get distorted with so many things, like sexual history and reputation is paraded in front of a room full of strangers, people that the complainant slept with years ago, no business being dragged into court at all. And it's pretty outrageous, the terrain over which cross-examination can reign. And even though there are laws that are meant to protect the victims from humiliating, distressing, intimidating questions. What question isn't of that nature in the first place, kind of? But the people whose duty it is to enforce those laws and object to those distressing questions aren't doing it. So it's sort of like independent legal representation in these circumstances isn't asking for anything new. It's just asking for existing legislation to be enforced. Like, y'all need babysitting, because it's not just traumatizing for the victim. It's actually leading to poor substantive justice outcomes. It's leading to victims withdrawing from cases, or the jury just having rape myths reaffirmed because a man in a wig told them so. And we've come a long way with independent legal representation. As you said, we've been advocating for this for years now. Why do you think it's been such a hard, pretending I don't already know, why do you think it's been such a hard reform to get traction on?
Yeah, we have a legal system that is extremely difficult to access. And, you know, that's a historical thing, right? I mean, our legal system was created primarily by men for men. It obviously has colonial roots. It comes from a very patriarchal structure, which means that there's specific people that are locked out of the justice system on a regular basis, and anyone experiencing disadvantage, vulnerability, or who's been negatively impacted by the patriarchy, which I would say is everyone, but specifically, women, trans and gender diverse people, will find it difficult to access the justice system, and we particularly see that in First Nations communities as well. And so when we talk about this issue, it's coming from a place of we're talking about a system that is not built for the people that we're trying to help, and so it's often difficult for people to kind of understand because it's not something that they've, I guess, been brought up to know how to navigate. And unless you have a law degree, or you come from a family of lawyers, or you have worked in and around the legal system, it's not something that you would have thought about in your day-to-day life. What do I do if I get raped? Who do I talk to? How do I engage with this system? And you might have only ever, learned about this from books you've read or movies or TV shows, and the reality is very different. And so I also find that it's very rare that people even have that kind of basic knowledge about the fact that victims aren't party to the criminal justice proceeding, that it's between the state and the accused person. And so, that's just kind of basic knowledge about the criminal justice system that you would learn in, legal studies maybe in high school, but probably not unless you have a law degree. Would you really kind of, think about that information? Would it be really front of mind for you? And so then what we've got is this complicated issue where people don't have much legal literacy, aren't given access to legal help that will give them the information they need. Then people often don't understand that that victims don't get lawyers in court. And then because of that lack of information, trying to fix the system and trying to advocate to government and trying to, get media attention on this issue is really, really hard, because it's just so far out of, I think, the day-to-day scope of what people understand the issues to be.
For me, it's like what you've said about people not knowing. We're not just trying to convince people it's a good idea. We're first having to explain to them that it doesn't exist, and then it's a good idea. But because people just assume, as you would, that the victim of sexual assault would obviously have a lawyer in the trial against their own perpetrator, a trial that would not exist without them. It's just like, you've got to do that first and then get over the shock horror of that. And like, that's not just to general like friends and family. That's like people working in government don't know that. There are loads of people who work in different parts of the law that don't know that. People just haven't touched sexual assault procedural law. So it's like I feel like we couldn't have picked something harder. I know we always talk about this. It's like, oh my God, it's just, I think the reason that we like do it is that it will represent like the single most fundamental shift of power into the hands of complainants since the system began. So it's huge, and the scope to extend representation and further support victims and further lift the integrity of the whole system, because as I always just like to drive home, this isn't just about mitigating trauma for victims, although that should be enough. It's not. This is about how the community expects the system to operate, because right now, like, we're putting the wrong person on trial. Like, it's quite simple, but people get the idea wrong. Like, for me, the ideas that people were getting wrong about this concept were that we were asking for the victim to become a party to the whole trial, like blow up the adversarial legal system, as if I would casually like advocate for that. And, maybe in the next lifetime, not in this one, but, no, we're asking for really limited, very structured circumstances for standing to be given. And it's specifically to enforce legislation that pretty much exists. It just needs a little bit of tweaking in some places, and we'll get to that. But it's like nothing new. We're just trying to actually make the system work as though those people, like, because like the bad guys set it up, like it doesn't even work the way you guys set it up to work, you know?
Yeah, and you can see that just in the fact that there's such low reporting rates and there's such low conviction rates compared to the significant numbers of women who are sexually assaulted throughout their lifetime. You know, currently the statistics are 1 in 5 women will experience sexual violence. And so, and then if you look at only 3% conviction rate, it's just, obviously the system isn't working and obviously some things need to shift. And it's not, what we're proposing isn't drastic.
Yeah.
We're just saying that victims should have rights throughout the criminal justice process in relation to the sexual assault that they experienced and that they should be listened to, and that the perpetrator should be properly held accountable in a way that is what the victim would like.
Yeah.
And I think
and what the community might expect.
Exactly. And, you know, what we're currently saying is that it's okay to rape someone because you won't be held accountable. The chances of you being held accountable are so small.
Yeah.
And
we've decriminalised it. And effectively we're emboldening perpetrators. You know, like reoffending is the most common type of offending.
Yeah.
Recidivism is on the rise and perpetrating is on the rise. And like, why are we shocked? Like we treat the harm as harm done to the state, as though the victim isn't a member of the state, you know? Like we've just forgotten the person who is meant to carry the case, and victims are withdrawing or outcomes are poor, not because the victim's weak or can't handle it, although it's a utter shock that they can or are even expected to, but it's because the system is pulling out on them, like it's failing them.
Yeah, and I think what needs to be front of mind for decision makers is that the criminal legal system isn't working for victims of sexual assault, and so it needs new approaches. It's different to other forms of criminal offending. It relies on the victim coming forward and almost entirely their evidence most of the time. And it's such a traumatizing thing for victims to be providing that evidence. And so, while I'm a really strong advocate of accused people having a fair trial and having protections throughout the justice system, I also think that, you know, there's so much evidence that shows that punitive sentencing doesn't work, and that it's really unlikely to rehabilitate people, to reduce reoffending. Like, we know all of these things about the criminal legal system, but that doesn't take away from the fact that we've told victim survivors, if you are sexually assaulted, report it to police, and then the justice system will be there to protect you and respond and do what you want. And the reality is so different from that. And so we need to find some way of both reducing the amount of sexual offending that's occurring in the first place, ensuring that victims understand their rights and have protections in place and can feel safe, and know that if they want help, it will be available for them, and they deserve to have their own lawyer throughout this process to make sure that they are protected.
What shifted that got this out of the too hard bucket? Those initial 3 pilots. Give me a spiel. Give me a spiel about our advocacy.
Yeah, sure. So I think it was around 2022, the federal government decided to fund some pilots that would provide legal assistance services to victims of sexual assault. And so this was a new thing that the Commonwealth decided to do. And so they decided to set up 3 pilots, one in ACT, WA and Victoria. And those pilots provide legal assistance, and some of them, I think, if not all of them now, provide representation in court to protect confidential counselling records from being accessed. And so that's a real shift away from the previous understanding that victims don't get a lawyer in the criminal justice process. And also, just to flag, I mean, before the pilots, there were also legal assistance services in Queensland and New South Wales for victims of sexual assault as well. But again, they were very limited just to protecting confidential counselling records. records. And so, yeah, the change that happened in 2022, I think, has been really significant. And that's recognising also that the Commonwealth government has a role to play in providing those services, because generally, legal assistance is kind of, it's always contested about whether it's a Commonwealth government responsibility or a state and territory government responsibility. Anyway, the Commonwealth took responsibility. They've funded those pilots, and through a lot of advocacy of yours and mine through the Women's Legal Services Australia network, we really pushed the Commonwealth, I think, to recognise the value of those pilots and to expand them. And so all of your advocacy work, Sarah, has just been so fundamental in getting those pilots expanded. And now there's one in every state and territory across the country. And that's only been in the last year.
It's so surreal, isn't it?
Yeah.
Like, because I remember zooming with the, what do they have? They have teamsing with the Commonwealth Attorney General's department about the pilots. And I was actually talking to them about something else entirely. I was asking them who the director of the Office of the Director of Public Prosecutions in every state and territory was accountable to. Separate can of worms there. And mentioned
the Attorney Generals. But yes.
Yeah. and mentioned legal representation, and first had to explain to them what that was and that victims needed that because they don't have that. So again, that thing of starting from like -0. And they suggested that we put in a submission and it be one of the pilots maybe. And then it's like all three of them. And as it should be, it's so obvious and commonsensical, but it's just that people don't know what happened, don't know it needs to exist in the first place. And then, of course, with the pilots now, a lot happened in the process to get those up. So we had the Australian Law Reform Commission.
Yes.
I was on the expert advisory group from that. I was feeling like a double agent, pushing from the inside and the outside. Like I was getting the commissioners to host specific roundtables with, the only people in the country working on legal representation, including the academics. And, there were like 3.
And let's not just gloss over that, because, when the Law Reform Commission was first set up, I don't think that their terms of reference, I was on the roundtable to help decide the terms of reference, but that didn't specifically focus on independent legal representation, whether there should be standing for victim survivors. And so what your advocacy did was get the commissioners to prioritise that, and then to actually hold a specific roundtable with the community legal sector and experts and academics to talk about whether independent legal representation should be a key part of the report. And then that resulted in recommendation 10 and parts of other recommendations as well, I think, particularly around funding the services. But recommendation 10 specifically said that victims should have standing to protect their confidential, sensitive and personal information. And that's incredible, to have that recommendation in writing so that now we can take that to all state and territory governments and the Commonwealth government and say, you need to reform your legislation.
And beyond just counselling notes as well was I think huge, because private, sensitive, confidential, that's a lot of things. That is vague and broad, and as it should be.
It's very broad, and it does. I think that we have to interpret the Law Reform Commission in the way that you would interpret the way that any judge or legal person speaks, right? Judges are the commissioners, or the commissioners are judges, ex-judges. And so essentially what they're saying is all personal, sensitive and confidential information should be protected, and lawyers should have standing to appear for those victim survivors in relation to that evidence. And that should include counselling records, health records, text messages, your phone, your diaries, your journals, and your school records, your employment records, just that there's so much personal, sensitive and confidential information that is captured by that recommendation. It's not just limited to counselling notes. And I think if they wanted to limit it to counselling notes, they would have.
I was running a campaign with news.com .au at the same time as these roundtables and consultations were happening, which is why I say I feel like a double agent. And because specifically I was trying to demonstrate that it's not just before the trial that these things happen. It's often on purpose. Late applications are made to access these private records, usually to intimidate the victim out of testifying, or to, it's too late, we can't halt the trial, it'll be too much of a delay, to refer them to a scheme, for example, in New South Wales and Queensland. And so I will never forget the day that the commissioner who was in charge of this specific recommendation, she was zooming in that day, she wasn't there in person. I just had my jaw on the floor, and I remember everyone in the room was looking at me because it was like my baby, and Karen's as well, Karen Isles, who we've had on the podcast, who her focus is on independent legal representation in the police process, and mine's been legal. And everyone just looked at me because even the people in the room, so many of them had their privacy invaded, and they didn't even know that was unlawful. And they were all looking at me to see my reaction because they didn't know if it was good or bad what the commissioner was, saying. And I went jaw on the floor because she said to me, it will be any time that those records are accessed or attempted to access. And I said, any time? So including trial, when late applications are made. And she said, any time. And I did not think, all I wanted was to get lawyers a foot in the door of the courtroom. I wanted them in the courtroom. And so obviously not like they're there as a party. There'd be what's it called? Adjudication.
I'm thinking gavel.
Gavel. I'm thinking
the arm movement that you're doing.
There'd be like pause here for a minute because something's come up, and it's not like the lawyer would come in and go, for shame, but like a foot in the door room, and it's like that and so much
adjournment.
Sorry,
I just remembered.
Thank you. There you go. Like it would look like an adjournment, but a foot in the door room. I was like 2 feet in the door room, 4 feet. Oh my God, like I did not expect that. And that's all I wanted, because now if we get this up, watch the floodgates open. There is so much scope to expand the role of independent lawyers. Again, not to do anything crazy, just to enforce existing legislation, maybe down the track to do some crazy things, because shake up the system.
We need to shake it up.
I'm all for that. But I was really over the moon. And it's a shame because it's the report as a whole is hella conservative. Like it's conservative. And in some aspects of the recommendations, they went, less far than former law reform commissions had gone. For example, the Victorian Law Reform Commission is quite progressive in what it advocates for around this.
Yeah, they've done some excellent reports in Victoria.
Yeah. And so this recommendation is kind of lost in that. And so, the whole role of my advocacy now and why I'm working with you is to bring it to light, because it can really change things, and it doesn't require a lot to be implemented.
It's just a few little tweaks.
Just a few little tweaks.
And and I think it's been really important that we're doing that mapping work to actually figure out exactly what the tweaks are that are needed in every state and territory, and then going to all of those state and territory attorney generals and saying, these are the small changes to existing evidence acts or criminal procedure acts that you could make that would have such a significant and substantial impact on victims' lives, and ensure that they have someone in court who can protect their personal, sensitive and confidential information. Like, it could just be such a game changer, and it's such a relatively easy change to make.
Yeah, it's like it's just getting over I feel like people don't advocate against it. There's just like misinformation about it. And all it takes is pointing to best practice overseas, not just in faraway countries like, Denmark, like the Scandi countries, or the Nordics, which are always seen as superior to the rest of the world on a lot of things. But in common law jurisdictions, like we lag behind so many other countries. We're really behind here. And it's like getting to the point of we're not meeting human rights obligations. And it's just a really simple one. It would really shift things, and I think the floodgates would open and we'd see the role, and ultimately we're saving so much money. Like, we're draining money right now with the amount of like health costs for victims, employment costs, like things plummeting, outcomes plummeting, including
Yeah.
justice outcomes.
Yeah, the trauma that's being caused by the system not working properly and the I guess the cost benefit analysis of just spending a bit more money
now
on
to
free
save
legal
money
assistance.
later. Yeah.
You know, if you invest in legal assistance at an early stage when someone's first experienced harm, violence, crime, particularly in the family violence space, it can have such a significant reduction in costs for government down the track in terms of their reliance on employment benefits, social security, you know, all these things that are needed once you've been significantly victimized or experiencing multiple levels of disadvantage and complexity in the way that the trauma has impacted you. There, you know,
And
the
all
costs
compounded with intersectionality as well.
Yes.
So everything's way worse for the majority of victims because, you know, I look like the minority, certainly, in terms of my privilege. Like, it's just huge.
Yeah.
It's huge, the costs saved.
Yeah. So, yeah, investing more in legal assistance at an early stage when someone's first experienced a crime, I think could have such a positive impact. And then the cost of legal representation, you know, it's obviously for at trial, that's a much bigger cost to have a lawyer there. But, you know, just at the pre-trial proceedings around just protecting access to those materials, that could be a significant,
But then I think, though, investing in pre-trial for what was decided pre-trial with a lawyer there to fall over in trial without the lawyer,
so
I'm like, well, is that a waste of money in the first place? Not saying we shouldn't have the lawyer pre-trial, saying we should have them the whole way through because, like, consistency. You know, often the judge is a different judge that was presiding. We've mentioned how the prosecution has to rightly be impartial, but they often have a fear of not looking impartial and let things slide more often than not. And, like, you know, even in the jurisdictions like New South Wales and Queensland where the, you know, counselling, communication, legal protection schemes have been running for over a decade now. It still relies on prosecutors knowing that exists, seeing the subpoena in time when they're juggling cases, and remember the victim's not in their interests. You know, they're not on their to-do list, referring them in time. I mean, I have a friend going through right now, and after all of this advocacy and all of this knowledge that I have, there's a prosecutor assigned to her case who's just adamant that the scheme doesn't exist. And, like, I've had her send him the legislation.
How can they say that?
I don't know. It's so weird. It's
so
like,
frustrating.
why are the people in these jobs not even across it? Like, I understand that the rest of the community isn't, but, like, what? This is why I keep saying victims' interests are the state's interests. Like, you need them to run this criminal proceeding. Like, you don't have someone without, the victim is your evidence, and all of these things aren't an add-on. They're like a precondition to the victim being there. Anyway, I want to talk about the pilots now, the rollout of the assistance pilots.
Sure.
So we've got all of the jurisdictions that weren't already the original three, Vic, WA, ACT, plus some double ups happening because we're using the pilots, the Commonwealth Attorney General is using the pilots to test some of the other recommendations like justice navigators, pathways to restorative justice, things like that, all of these important things. Right now, what can these lawyers do and what can't they do? Like, if someone went to one of the services today, what would they receive? Assistance, right? And assistance can't be underestimated.
Yeah, so it differs between every state and territory what you can get access to at the moment. And we've also got to remember these are pilots, right? Yeah. So they're relatively small. There's just a small number of lawyers or social workers or sexual assault workers providing these services. And so, you know, the amount of people that can access them is also still relatively limited. Yeah. Obviously.
Which would be also, side note, heartbreaking for the lawyers as well.
Yeah.
Like, people don't talk enough about the vicarious trauma of being a victim's lawyer, especially with the way funding is currently set up.
Totally. They deserve to be paid so much more than they are.
And have regular, like, consistent meetings, not just a one and done with the victim and then not know what happened after that.
That would be really hard.
Sorry to interrupt.
No. Yeah, I think that's right. The work of lawyers in general within the community legal sector is so fundamental to ensuring people have access to justice, and it is not appropriately recognised by I think by the community, by governments, for the significant value that it has. And yeah, those lawyers are often significantly underpaid. But yeah, it can be really traumatizing to do that work, and there's a lot of burnout within the community legal sector. Women's legal services primarily assist victims of family violence, and so there can be a lot of trauma associated with that work, or vicarious trauma, sorry.
Yeah.
And, a lot of sexual assault occurs within the context of an intimate partner relationship.
Yeah.
So there's often
Yeah.
that overlap between family violence and sexual assault. So the services that you can get when you access a pilot will really depend on, I guess, where you're at in the criminal legal process, whether you've decided to report to police or not, whether you want to pursue a restorative justice approach, which is an alternative to reporting to police in some circumstances. Although I think sometimes the requirement is that you still have to report to police.
Which kind of defeats the purpose of restorative justice. Anyway,
Yeah.
separate can of worms.
Yes. So
Many of them today.
so much to talk about. But if you are a person who's also experiencing family violence, you might also be on a visa. So you might need help with migration law, particularly if it's your partner who has sexually assaulted you.
Yeah. And then your status is dependent.
Exactly. So you might need help with that as well. It might be that your employer sexually assaulted you, in which case you need employment law help as well. And so you might get referred to a working women's centre.
Compensation schemes, they can help with it because they are awful. They need reforming too. That's been covered in the Australian Law Reform Commission recommendations. But even as they stand right now in their limited ability to provide recognition or support to victims, they're so confusing. Those forms are so confusing. Like anyone would need a lawyer to fill them out. So I feel like that's a good one as well that can be provided.
Yeah, so victims of crime compensation schemes exist in all states and territories. They've got different names, but essentially, you can get compensation depending on what you've experienced. There's been reforms in some jurisdictions to improve access for victims of sexual assault, where, for example, you don't need to prove certain things.
Disclosure, like to police or whoever else.
Exactly, yeah. But there's more that needs to be done to improve access to those for victims of sexual assault, for sure. But yes, that is legal assistance that you can get help with. But in terms of the criminal legal process, it'll be advice about your options, how reporting the crime could affect your other legal rights, and then explaining how the criminal legal process works. And that's something that justice navigators often do as well, but obviously they can't provide legal advice because they're not lawyers. But understanding the process, understanding your rights, understanding what protections exist, that's really fundamental. So what protections you can seek to have enforced around your confidential and private and sensitive information, and then whether you want to do a victim impact statement, what that would look like, and also where you can ask to be consulted on certain decisions. So I think it's really great to see that in some jurisdictions the victims' charters actually say where prosecutors have to consult you on certain things, and so your lawyer can help you, I guess,
just make sure it happens.
Yeah, make sure it happens, but also maybe even help you communicate with the prosecutor or with police.
Because if you don't know what is available, like that legal literacy piece, you don't know what you can advocate for or what you shouldn't waste your breath on, which often happens because, victims are finding out the day of trial that they don't have a lawyer. Like people are seriously unaware. And it's a complex system, but even that fundamental piece of it, knowledge about it is missing.
Yeah.
I think as well about alternative testimony, like witness arrangements, like delivering your testimony in different ways via video link or with a screen up.
Or
pre-recorded, special arrangements, like, I don't know, having your own bathroom. I had to share a bathroom with my perpetrator, things like that. So all these things that they add up, like they're huge. So assistance as opposed to representation, which we're describing there, is so important.
Yeah.
And early assistance, which is the key there.
Totally. And it's interesting you talk about those protections around, being in the same bathroom at the courtroom, things like that. So what some states have is what's called ground rules hearings, where you'd have an intermediary that will help get certain protections in place around things like how you kind of navigate the courtroom, how you give evidence, all those kinds of things. But even then, it would still be great to have a lawyer to help to make sure that the intermediary knows what you want, and then that matches up with what you want throughout the whole process, and can think about how that might affect your, the way that you provide evidence, things like that. So I think it's useful to have a lawyer to support you no matter what part of the justice process you're going through, or an alternative process, just so you always know what your rights are and what's happening.
I love that we say just so, as though that isn't the bare minimum.
Yeah. Know what you're entitled to, what your rights are. And that is so important and so empowering for people.
I want to end with something cheesy.
Sure.
Why does this reform matter to you? Why are you here on Struggle Street with me?
Well, look, that's a really interesting question because, I've come to this issue because it was a priority in the work that I was doing as the Executive Officer of Women's Legal Services Australia. And so, it was really important for the Women's Legal Services to be advocating for there to be lawyers that are funded to do this work, because that's work that they can do, and they have that expertise, and they are gender-led and trauma-informed, and they're well-placed to assist victims as they navigate criminal processes. But now I'm doing this work with you as a consultant, and also, it's really personal to me as well, because I not only did it as a job, but I started to see the significance of how much impact this could have on people's lives, and how deeply traumatic the criminal legal process is for victims of sexual assault and for victims of family violence, who are predominantly women. And as a feminist, as an intersectional feminist, I can't not care about this now that I've seen how important it is and how much of a difference it could make. And, I've got a history working in politics. I've worked with decision makers all across the country. I feel like I'm and I also have a law background. So I feel like I'm in a unique position where I have the skills, I have the ability, and I have the time and the, the relationships and all these things to actually help make this happen. And so it just feels like it's such an important use of my time. And so I'm really grateful to have the opportunity to work with you, Sarah, and to, be on this podcast and to be advocating for these reforms with you, because, we need to be listening to people with lived experience. We need to be elevating their experience and communicating that to government. And then we need to be putting the pressure on government to make these changes to improve people's lives. And that's really worthwhile work.
Love that. Great answer. Okay, well, we best go get some lunch.
Yes.
Thank you for being here and sharing your very multifaceted bits of knowledge about the system.
You are very welcome.
Your brain is big. I don't know, and I'm very happy to be doing this work with you. I don't think I could be doing it without you.
You could, but I'm glad to be here.
Just tell me more. Yeah. Okay. Well, I guess I would just end by saying to keep an eye out for the work that Lara and I are doing, because this is gonna get up if it's the last thing we do.
Yeah, we're gonna make it happen.
Yeah.
If you've listened this far, you already know something most Australians don't. Victim survivors are the only people in sexual offence trials without their own lawyer. That doesn't have to stay true, but justice systems don't change because they quietly evolve. They change because people understand them and demand better. Go to withyouwecan.org to be a part of that demand. This has been What No One Told Us.